All right, everyone, good to see you. For those of you who don't know me or are new to ACUS, my name is Kaj Novatsky. I'm the Deputy Research Director here at ACUS, and I'm the staff counsel for this project on drafting regulatory preambles. I'm just going to call roll to start with and then turn it over to my colleague, Jeremy Graybois, who's our research director, and then to Kirti, who is our committee chair. So I'm going to call two rolls. The first roll will be of ACUS members that are on the Judicial Review Committee. The second roll will be ACUS members who are not on the Judicial Review Committee. So if you could just unmute yourself when I call your name and say here, just so we can make sure your microphone is working, that would be appreciated. We'll start with our committee chair, Kirti Datla.
Here.
Thank you. Nick Bagley. I don't see him yet, but he is attending. Giancarlo Canapero, alternate for Daniel Burrows.
Here.
Awesome. Good to see you, Giancarlo. Don Elliott. Don't see him here yet. Betty Jo Christian. I see you here, Betty Jo. If you can just unmute yourself so we can get a test for your mic, that'd be great, or we can come back to you. Okay, we'll come back to Betty Jo. Abby Gluck is going to be joining at 1. Kristen Hickman.
Here.
Great, thank you, Kristen. Paul Kamenar.
Here.
Thank you, and I know that you're with us until 2.
Right.
Ron Levin will be joining at 12:45. Courtney Mallon.
Here.
Awesome, thank you. Let's see. Alan Morrison.
Here.
Excellent, thank you. Heather Sokolauer. So sorry.
Here, did you hear?
Yes, is it Sokolauer or Sokolauer?
Sokolauer.
Okay, thank you so much.
Okay.
Dave Trissel. Not here yet. Okay. Is there anybody who's on the committee of judicial review whose name I did not call?
Yes, me, Dan Walters.
Hi, Dan.
Hi.
So sorry I missed you. You were right at the end. Okay. And then I'm going to come back to Betty Jo. Are you able to unmute yourself at all? Okay, maybe she stepped away for a bit. Okay, and then again, is there anybody on the committee of judicial review whose name I did not call? All right, hearing none, we'll move on to ACUS members who are not on the committee, and also our consultant. So our consultant is Dan Deacon. Hello.
I'm here.
Awesome, thank you. Chin Yu will be joining us a little bit late. Amy Bunk.
Here.
Excellent, thank you. Bill Funk. He'll be joining us at some point. Miriam Vincent.
Here.
Thank you. And then Matt Weiner.
Here.
Excellent, thank you. Is there any ACUS member either on or not on this committee whose name I did not call? All right. That's it for the roll call. I'm going to turn it over to Jeremy.
Thanks, Kasha. I know we have a lot to discuss today, so I will be very brief. Great to see you all. Welcome to today's meeting. And obviously special thanks to Professor Deacon for an outstanding report, Kirti Datla for chairing today's meeting, and Kaja, thank you for shepherding the project through. So I'll turn it back over to you.
Great, thanks. I'm just going to turn it over to Kirti.
All right, great. So I'm gonna just go over the standard meeting protocols now. So please note that only ACUS members, which includes government members, public members, senior fellows, liaison representatives, and special counsels, whether or not on the committee, and designated alternates, have full speaking privileges. I think everyone is muted, but to avoid background noise, please keep your microphone on mute, and then either use Zoom's hand raise feature or If you're having trouble with that, add a comment in the chat feature if you'd like to speak, at which point I will call on you and you can unmute yourself. And then when you're done, remute yourself. I'd also ask that ACUS members and their designated alternates turn your cameras on if you can to facilitate a more natural conversation. And with respect to attendees other than ACUS members and alternates, participation will require the unanimous consent of the committee members present. Time permitting, I will consider calling on such attendees at appropriate points and will presume committee consent absent anyone raising an objection. If any such participant would like to speak during the meeting, please indicate so in the chat function or by using the Zoom hand raise feature, but wait to speak until I call on you, at which point, as I mentioned before, you can unmute yourself and then remute yourself when you're done speaking. For everyone, please use the chat feature only to indicate that you would like to speak or for committee members and alternates to vote if needed. Please do not put substantive discussions or sidebar discussions into the chat feature. Finally, only members of the Judicial Review Committee have a vote. Please do not vote unless you are a member of the committee. We have a list of committee members in case you are unsure, so you can always ask in the chat if you need clarification on that. So I will turn it over to Dan Deacon to provide an overview of the project and the draft report.
Sure, thanks, Kirti, and thanks everyone for your interest in the project. So I think the sort of sentence level description of the project is best practices for regulatory preambles in light of recent developments in judicial review of agency action. So that left some play in the joints. I worked with ACUS to come up with sort of our set of topics. It was clear that Loper-Bright and major questions doctrine were sort of like in from the beginning. And then the report also focuses on a sort of very varied set of arbitrary and capricious review issues that I had considered to sort of be in the air recently in judicial review, particularly at the Supreme Court level, but in the lower courts as well. So that left us with Loper-Bright major questions doctrine, matters that I kind of grouped within what I was calling, or what I called in the report, the agency's affirmative case. It's sort of justification for switching from the status quo, how to respond to comments, alternative identification response, and issues involving administrative change. So in terms of the research, I talked with 19 agency rule drafters, and some of their characteristics are discussed in the report. And I would say the dominant theme was something like recent developments, including Loper-Bright, haven't necessarily fundamentally changed what we do. Here I'm speaking as the interview subjects. Haven't fundamentally changed what we do, but have introduced certain complexities and also reminded us basically to do everything well. And those drafters gave sort of very useful advice on, or useful ideas about what doing everything well sort of means with respect to particular topics. So in addition to those interviews, the report's based on my own review of the case law, my own review of academic commentary, my own review of recent agency preambles. And I would say that the resulting draft report tries to walk a certain line. On the one hand, I wanted to use my interviewee's wisdom as well as the other sources that I was consulting to get a little bit more specific than do a good job or do everything well. On the other hand, I didn't want to get so specific that the recommendations would simply be sort of swept away by time in the next sort of like 5 years of development in the field. So added to that difficulty was sort of a difficulty in the draft report of that, identifying general principles is difficult because much, especially when it comes to arbitrary and capricious review, but also when it comes to statutory interpretation, is necessarily context sensitive. So what comments are significant, what alternatives are reasonable, are all things that depend heavily on the nature of the policy question. So I tried in the draft reports to provide sort of general guidance, but it's necessarily quite general, and I have sort of caveats in the report that these aren't meant to be one-size-fits-all suggestions, which is something that I'll reiterate in a minute. So maybe I'll just say a few words about the Loper-Bright stuff in particular, because I think that's the meatiest part of the report and probably, I'm guessing, where people have the most thoughts. So I'm of the view that we don't really know where courts are going with Loper Bright, that there are sort of multiple paths open, just reading the face of the Loper Bright opinion itself. So what I tried to do, sort of like in line with the line that I was describing earlier, was sort of like make suggestions or suggest places in the alternative where agencies could take sort of multiple roadmaps to justifying particular conclusions that they had come to. Somewhat unfortunately, again, in line with what I said at the outset, this sort of boils down to kind of like do all the things. So do all the things, but also do all the things well. And I think the draft report has a little bit of that flavor. And I think that's true of the Loper Bright stuff, both in the sort of bucket of considerations that has to do with identifying situations where the agency is exercising delegated discretionary authority. So there, I think there are sort of multiple paths open to courts in the future, or different ways that we might go in determining when agencies have such authority. And then I think something similar might be said about sort of agency-provided interpretations more broadly, including in situations where a court will be exercising final interpretive authority using its independent judgment. I think there's this idea out there that Loper Bright means everything is about the text now. And I think one theme of the report is that, yes, the text is very important and something that often makes sense to start with. But that, and this was really reinforced by many of the rule drafters I spoke to, it's not always so clear that that's going to be the end of the matter. And one thing the report stresses is suggesting to agencies the continued need to provide sort of full justifications for their interpretations using a variety of different kinds of interpretive tools, especially I would say within the sort of like domain of cases that would have previously been governed by Chevron Step 2, and thus would have been considered sort of like ambiguous, particularly at the textual level under Chevron. So final thing I'd say is the caveat, which is the sort of do everything and dial it up to 10 theme of the report, I would say is not meant to be universal. One thing that really came across in my interviews with agency folks was that actually in many cases, agency rules are making sort of incremental adjustments in areas where an agency has pretty established authority and probably pretty clear authority under the statute. Arbitrary and capricious review issues are still going to be important to attend to, but I don't want to suggest that, in all cases, agencies need to do, every single thing I mention in the draft report. It's really, again, going to be much more context sensitive than that. But for purposes of a report that was trying to be comprehensive, I necessarily included things based on contingencies that agencies might face in making decisions that they do. So with that, I look forward to the conversation.
Great, thanks, Dan. Kaja, are we gonna throw the document up, or we're just gonna dive into discussion? Either way, it's fine with me.
It is up to you, whatever you want to do. I think probably a broad general discussion might be helpful first.
Okay, great. So yes, so as I think folks know, or maybe might not, so I'll clarify, the hope for this meeting is to get general reactions to the content of the preamble. So not so much the, nitty-gritty details of the wording, but is this the kind of thing we should be including in the preamble? Same for the recommendations. Are these the kinds of recommendations we should be including in this report? Is there anything that should be taken out? Is there anything missing? And that will give the committee staff the ability to go back and revise for a more fine-grained discussion in later meetings. So I think to that end, I want to actually start with Bernie Bell's first comment, even though he's not here. So I'm not sure if folks have had time to look at it, but the overarching thrust of that first comment is raising a question about whether the recommendations generally or any of the specific recommendations are aimed at providing advice about how agencies can maximize the chances that their actions will be upheld, versus sort of maximizing clarity needed to allow for effective judicial review. So I want to open the floor to comments in reaction to that first. So again, you can either use the Zoom hand raise function or note in the chat function if you want to comment on that. Okay. If all right, Paul, do you want to unmute and ask the question?
Yes, I actually want to ask a preliminary question, not on this particular. Obviously the recommendations cover notice of proposed rulemaking and the rulemaking itself. It doesn't cover, and it probably was not intended to cover, advance notice of proposed rulemaking. That's not required by the APA, but a lot of agencies do that. So I'm just wondering whether or not in the very beginning, you may want to drop a footnote so that the reader know that this recommendation doesn't cover advance notice of proposed rulemaking, or maybe at some other point, we may want to recommend it to do that, or at least recommend that the agencies utilize advance notice of proposed rulemaking more so that they can get ahead of the curve in terms of comments that may be coming in.
Okay, thanks. I'm going to turn it to Dan to do maybe two things. One, confirm whether that assumption is correct, that this isn't meant to apply at that stage. And two, whether there are distinctions that would make it worthwhile to drop that kind of footnote or caveat that it doesn't apply, if that's right.
Yeah, I mean, I wouldn't say that's the recommendations are irrelevant probably at the advance notice stage. You know, the things about what kinds of alternatives might make sense to flag might carry over to the advance notice stage, for example. But I do think I would affirm that it wasn't our focus in this report. We were basically focused on the NPRM and the final rule and the preamble attached to those. So I wouldn't really think it would be wrong to drop a footnote saying that this ANPRMs just weren't our focus here.
Okay, thanks, Dan. The other Dan Walters, do you have a comment in reaction to that, or was it on the earlier point from?
It was on Bernie's points, but I think Kristen was ahead of me.
Yeah, exactly. So Kristen, do you want to go?
Well, and I just can't figure out how to raise my hand all of a sudden, notwithstanding the fact that I've been on Zoom a ton in recent years. You know, I take Bernie's point. Actually, let me start by saying, Dan, this is a great report and preliminary set of recommendations, and congratulations and thank you for all your hard work. But in response to Bernie's point, I take his point to a certain degree, but I also would suggest that maximizing the likelihood that a rule will be upheld on judicial review and the points that Bernie is raising are not mutually exclusive. That, you know, if you follow the, at least generally speaking, as I've read through the draft recommendations, if you follow sort of the suggestions here, you're capturing the actual reasons a regulation is being adopted, at least hopefully, and you're not relying on pretextual arguments. I mean, if you're truly relying on pretextual arguments, there are cases in which courts reject those arguments precisely because they're perceived as being pretextual. You know, and if the agency has policy discretion, well, under Loper-Bright, I mean, Dan's right, Loper-Bright jurisprudence at the lower courts is a mess right now. But, you know, if the agency thinks it has policy discretion, it should assert that discretion as part of its statutory interpretation argument. And I don't know, maybe I'm missing something, but I don't know that the recommendations necessarily counsel to the contrary of that. You know, the purpose of a preamble is to communicate the agency's thinking. It strikes me that the recommendation is providing guidance in the sense of the kinds of, you know, the kinds of common sense things that help an agency order the articulation of its thinking. Anyway, I'm going on too long, so I will turn it over to whoever, Dan or whoever else.
Thanks, Kristen. Yeah, Dan, you're up.
Yeah, so I also wanted to speak to the concern that Bernie raised, and I think I agree with Kristen that it's not a serious problem, but there is something I think we should do maybe to improve this, and that's actually to cite the Department of Commerce case, other cases that talk about pretext, and simply remind agencies that this isn't a checklist. You don't have to say something on everything, particularly if it is pretext, and there could be a risk of courts invalidating agency action if it amounts to pretext. So I think just a little reminder of all of those features of this recommendation would be enough. Citing those cases directly and then just saying, yeah, we're giving you sort of a bunch of different things that you might think about, but they're not going to be applicable to every case. This isn't a checklist. You need to go down and check off each individual option in each rule. So I think that's how I would approach Bernie's concern. I don't think it's an existential threat to the recommendation or anything.
Thanks, Dan. I think I'm going to exercise the chair's prerogative just to note and recognize that I am risking speaking for Bernie without him being here, but I'm not sure I took pretext to mean something negative, but more that we might be encouraging, even if unintentionally, agencies to not offer a view of statutory interpretation or a justification for their policies that might be different from what your kind of average reviewing court might find most palatable. So more like silencing themselves as opposed to being pretextual in a maybe more negative sense. So I'll just say that just for the purposes of the discussion. And then Don, you were up next.
Thank you. I'm sorry to have been a little bit late from a dental appointment. So I just recently joined, and I did not hear the arguments that were made earlier, but I did from the comments have a somewhat similar reaction. I thought that the recommendations were really advising agencies as to how to maximize their chances of being upheld on judicial review, and that's certainly part of it. But I also, based on my experience a number of years ago, I often found that the lawyers that were writing up the preamble, either at the proposal or final stage, really hadn't been in the room when the decision had been made. And I do think it's important to recognize that there is an obligation to try to get accurately into the preamble the actual reasons that the agency acted as it did and the factors it considered. I've got some specific suggestions when we get to that point, but just as an overall comment, I do think there's an important function that the Judicial Review Committee should be supporting of making sure that agencies accurately reflect the considerations that actually motivated their decision. And I don't see that really reflected as clearly as I think it should be.
Okay, thank you, Don. Alan, you're up next.
Oh, first, I want to thank Dan for a really excellent report. When I started reading this, I said, what's he going to write about 70 pages about what's going on there? It's just a preamble, but it's really very well done and nicely divided in ways that are manageable and useful for agencies and for us. Second, as to Bernie's comment, I mean, I think when an agency decides to issue a rule, it should be encouraged and told how best to defend its decision to issue a rule. And so I don't think we should suggest it as being agnostic on this question or neutral, just that it has to be honest and not have pretexts. Can I make, as long as I have the floor, one other suggestion at this point, which is when I started reading this, I thought regulatory preambles. I don't notice that that word is any place in the APA or anything like that. And I wonder whether, I know that's what the council presumably has assigned this topic, and it is a preamble, but preambles seem kind of like a much, sort of like a preface to a book. This is much more than a preamble. And so I'd like to just put it on the table now and come back to it later, changing the title of this to the statement of basis and purpose, because that's what the APA language 553C says. And we ought to think about whether this is a, somebody's going to look at this, oh, preambles, I won't pay any attention, but the required regulatory statement of basis and purpose, whether we want to think about changing it to that. Thanks.
Okay, thanks, Alan. I think on that second point, there's going to be lots of reactions, so I want to table it until we finish discussing Bertie's point. And Kristen, I think you were next, and you raised your hand while we were still discussing that. Is that right?
Yes, I did.
Yeah,
And
okay.
you're right. I have a very, very visceral reaction to Alan's point. So I hope we can get to that before I have to jump off this call. But I just to follow up on something that you said about the concept of pretext, and the real concern being that agencies might silence themselves out of a concern for expressing views that in the preamble that might result in might give them a problem on judicial review. I suppose there's an extent to which I would suggest that if an agency is concerned that some rationale that it has for a rule might cause problems on judicial review, that maybe that's a reason why the agency ought to second guess whatever it is that they're thinking. Maybe I'm naive about these things, but at the same time, if they think that a thought might cause them problems on judicial review, that suggests that they're doing something they shouldn't be doing. So, I don't know. I don't want to encourage agencies. I want to encourage agencies to be forthcoming. And yet at the same, because I think that that's in everybody's interest, including the agencies. But I guess if we're going to try, if we're going to take Bernie's point and we're going to we decide to say something about pretext, we ought to take some care in what we say and how we say it, I guess, is what I'm trying to say. I don't know.
Thanks, Kristen. Alan, I want to make sure that your hand is still raised from before and you weren't re-raising your hand. Okay, great. Thanks. And then, Bill, do you have a comment on this point we've been discussing about Bernie's first general reaction? Okay,
Yes,
great.
and I'm sorry I came in late, but I did read Bernie's comment and sort of picked up on some of the reaction here, and want to say that an awful lot of important rulemakings that the explanation in the preamble or statement of basis and purpose, Alan, is not the reason why the agency did what it did. It is the justification for it. And I think there's a difference between reason for and justification. I mean, a long time ago when I was writing rules, and at least one rule that we did, it was dictated, it went to the White House to decide how it would come out. It was sort of a yes or no question. And from our perspective as the people who were on the ground writing the rule, it could be justified either way. It was a close call, all right? And so it was a close call. But the call was made at the White House on a strictly political grounds. And I think the idea that you would say in a rulemaking statement of basis and purpose, the president dictated that the answer should be this, and we think this is justifiable, all right? Blah 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 blah, is not realistic. I mean, it's just not going to happen. And if we adopt the kind of recommendation, I don't know if we'd get through the council, but if we adopted a recommendation that called on people to be quote unquote honest, all right, I think it goes nowhere. I think the idea that There must be a statement that justifies it on a legal basis of why what the outcome was is legally justifiable, is different from the motivation or why somebody did something, the motivation. It just has to be justified on the law and the facts. And if that's not really why they decided it, I mean, go back to Sierra Club versus Coastal. I mean, it's not the nature of important rulemakings to have the preamble be, as they say, totally honest. So I'm not upset about things that might fall under Bernie's pretext concept, because it's just the nature of rulemaking to not refer to certain inputs that are not of a legal or factual nature.
Thanks. Abby?
Hi, everybody. I came in very late and I'm dealing with a family emergency, so I missed the beginning of the discussion, but the last comment just motivated me to raise my hand because and I'm coming in and not having heard the prior comments, so please excuse me if this is not relevant. But if the question is how purpose is to be used in the preamble, I think that part of what's going on with this recommendation is thinking about preambles in the wake of Loper Bright. And there's another suggestion on the table I assume we're going to be talking about later today about the extent to which this recommendation should be about agencies thinking about how to best justify their rules for reasons of having them upheld on judicial review, or whether other reasons should be motivating what goes in those regulatory preambles. But to the extent that we care about a court doing ordinary statutory interpretation, judicial review, then I agree with the prior comment about purpose clauses. I mean, the test of just purpose would be not political motivation, but the purpose of the statute and the way in which the regulation proposed gels with the objective or stated purposes of the statute at issue. So hopefully that's a relevant comment and not an irrelevant comment. And if it's irrelevant, I apologize.
Thanks, Abby. I think the bit that you missed at the beginning is that we did start with the comment that you referenced, and then the discussions just shifted a little bit.
With Will Funks, we started with that.
Oh, sorry, I was referring to Bernie's first comment, but
I just meant I heard that part, but my point was was related to the point that's raised in Funk's recommendation, which is what is the point of the regulatory preamble? And you can't really answer the question about what the role purpose plays in a regulatory preamble unless you're thinking about what the point of the regulatory preamble is, right? And if one purpose is for it to be sustained on judicial review, then you want to be thinking about purpose from a particular kind of statutory interpretation lens, as opposed to the other kinds of considerations that were just being mentioned.
okay. Thanks, Abby. Giancarlo?
Yeah, thank you. This is my first meeting, so thank you for inviting my boss, who I'm representing today. I just wanted to say I second the last two comments, Professor Funk's, especially as somebody who's presently writing rules, from that this has not changed. But that being said, I do want to see agencies, to the extent appropriate, be more forthright about policy reasons that they're adopting a particular interpretation. I think that's well covered by the recommendations already, which seem to carve out some room for agencies to do that when they've got that discretion.
Okay. I'm going to pause and see if anybody else has general reactions on Bernie's first point and the related discussions we've been having. And if not, recognizing Kristen's desire to respond to Alan, I think it might be most productive to turn to Bill Funk's first comment and the reaction that Abby had, and we will, I promise, over the course of the next 4 meetings, air out the title question. Bill, I want to give you a chance if you wanted to just state in your own words the first comment.
I'm not even sure what my first comment was because I sent you a whole markup, so I'm not exactly sure which first comment you were referring to. You mean my written comments?
Yeah, yeah. Well, why? Okay, well, I won't put you on the spot then, and we'll call it Abby's comment about what is the purpose of a regulatory preamble, and is the recommendation taking a position on that, and if so, is that the position this committee wants it to take a position on? So I'll open the floor to comments on that general question. And actually, I want to, Dan Deacon, if you wanted to react to that, I want to make sure you have a chance, but no pressure.
Sure. I mean, I think preambles serve many purposes, and trying to satisfy the multiple purposes. I mentioned this in the draft report. May actually require some compromise among how to do things. You know, I was focused on preambles in light of the agency's, you know, obligation or need to follow, you know, the instructions recently provided to them for purposes of APA review. So that was kind of my focus in terms of the draft report. But I do acknowledge that regulatory preambles do serve a number of other functions, and sometimes it could be that a preamble that perfectly you know, does a perfect job with judicial review. The judicial review function may you know, may require some compromising of other sort of purposes or aims. I don't know if that's responsive, but that was sort of my.
Yeah, it is. I have a question, since I don't see any hands up. This is, so in Bernie's comments, he says, at the very least, the recommendation should acknowledge that recommendations are focused on guidance and crafting agency preambles for the purpose of facilitating judicial review. Do you think that accurately, recognizing that these preambles serve multiple purposes, do you think that accurately characterizes the draft recommendation as it stands?
I do. That would be my perspective. Yes. So this was, you know, about the judicial review function, this particular project, and not meant to denigrate or suggest that other functions aren't also important.
Okay, so that might be one option for the committee staff to consider, is making that more express. Miriam, I see your hands raised.
Yeah, and this is reflected in footnote 7, just as an aside. I don't know that it really adds much to the discussion because we don't get into much detail. But there is a regulation that describes what goes into supplementary information, which is, yeah, basically background, differences, important points, and then it leaves it wide open for agencies to discuss what agencies think are really important for the specific rulemaking. So with any changes that you need to make. But then that can also include very, very specific changes if an agency is not actually including the proposed amendatory language as part of that rulemaking. So, I mean, I don't know how much that helps or doesn't help. And it may just be sort of irrelevant that there's a regulation that requires some things, but it is way too vague to be of any substantive help in drafting and trying to meet a judicial review standard as well as serving the public and serving other agencies and explaining what you're doing and still being able to defend your decisions and, you know, your proposal and ultimately your final action in what you're doing.
Thanks, Miriam. Okay, so we're still on the topic of kind of what is the purpose of a preamble and whether this document says what it needs to say about that. So Kristen, if you have a comment on that, you're up next.
Yeah, I mean, I will make the observation that I quite like the articulation of regulatory preambles serving several objectives that is currently in the preamble to this recommendation on lines 20 through 29. However, I do think it is doctrinally accurate to state as well that preambles facilitate judicial review. I think you only have, you know, the first case that comes to my mind is Citizens to Preserve Overton Park. I think even though it dealt with an adjudication in sort of talking about agency explanations of what they're doing as support and agency administrative records as facilitating judicial review under 706(2)(a. You know, I think State Farm, you know, it's all over State Farm as well. And, you know, you can just go on citing chapter and verse of a variety of different cases. So I don't think it's problematic in any way to state that a purpose of a preamble is to support the agency and, you know, in judicial review or facilitate judicial review. Since the current list of objectives of regulatory preambles that is in the preamble to the recommendation does not mention judicial review, I think we ought to add it.
Yeah, thanks, Kristen. So I think the next paragraph does mention judicial review, but the topic sentence is more comprehensive than that whole paragraph I take to be about judicial review, but the topic sentence actually suggests it's not focused on that. So I think we can do some revising to make it clearer that one, we are really focusing in on judicial review in that paragraph, and then maybe considering adding the line from Bernie's comment that the rest of the recommendation is focused on that aspect of what preambles achieve. So hopefully the Kaja and Jeremy have that down. Okay, great. Alan, do you have another comment on the same topic, or did you want to raise something different?
I think it's the same general topic, depending on
Okay.
the level of generality at which we're approaching this question.
That's a lawyer's trick, but okay.
I fear sometimes that agencies and their legal staffs write these preamble statements of basis and purpose because they kind of are checking a bunch of boxes and want to do it. It seems to me that if I were doing this, one of the first things I'd want to do is to try to sell this rule as a good idea, that you want to make the people want to adopt the rule or not reject it. That gets lost. And I don't think we say that. And but I hope we will say that the agency's job is to sell this to the regulated communities, the beneficiaries of the communities, the Congress, the courts, and everybody else. And they sell it as both as a matter of policy, why it's a good idea, and why it's lawful. I'd like to see us say that up front someplace. I don't think it's inconsistent with anything that's in the report, but I just don't. And it's partially because agencies, I think, do not think about this or react this way. So anyway, that's my suggestion. I hope it's on point at this time.
Okay, thanks, Alan. I think that gives Kaja enough to work on, but if you have specific language that you want to send over between now and the next meeting, I'm sure that would be appreciated too. Unless there are other comments on this point, I know Dan Walters has a point he wants to raise. So we'll go to that if we're wrapped up here. Okay,
Great.
Dan?
Yeah, so this is like a complete 180 in a way, but it was just a general reaction that I had reading the recommendation, and specifically comparing the preamble to the recommendation itself, and then the report. And what I'm worried about is that it would be kind of unintelligible and very difficult to understand the specific recommendations without more background in the preamble to the recommendation about the cases that this is responding to. So, the recommendations presume kind of background of certain categories that might be relevant because of Loper Bright, because of changes in arbitrary and capricious review, all of which is very well laid out by Dan's report. I think it's one of the great things about many great things about the report, but it's just sort of not in the recommendation right now. And I would if I was reading this without any background, I wouldn't have any clue why the recommendations were popping up, what they were responding to, why they were justified. A lot of the preamble is really focused on prior recommendations about preambles and the other purposes for having preambles, but it doesn't say a whole lot about the judicial decisions that are really motivating this recommendation. So I don't know. It's a very general comment. I don't know if other people share the same reaction, but I do think a lot more background about the cases in the preamble would be helpful. I admit that might be tricky because we don't all agree about all of the different categories that might be relevant coming out of Loper Bright. But I think you have to do something on that front. Just a little bit of here are the different things that are being talked about as potentially relevant categories of analysis under the doctrines. Maybe not saying like, this is for sure going to be what courts are going to do, but this is maybe in the ether. These are things that courts might be thinking about. I think just some background there would be really helpful. So anyway, just throwing that out there. Sorry for being long-winded.
No, thanks, Dan. I think that's exactly the kind of feedback we were looking for. Alan, is your hand up from before, or is this a new?
Be able to take it down again.
Okay, no problem. I think we would welcome thoughts on how to walk that difficult line that Dan raised about how to discuss the cases in a way that committee members will be comfortable with, and then eventually the full body. But while people are thinking about that, Don wanted to make a comment.
Well, I agree with Dan Walters. I think it would be helpful to suggest that this is not necessarily a comprehensive account of writing preambles for all sorts of different reasons, but so perhaps just the title, writing preambles in the wake of Loper Bright or something like that, to essentially, and if you don't want to change the title, you can also you could also do it in the preamble to our recommendations in that preamble. But I do think it's helpful to suggest that this is particularly focused on what agencies should do. I was involved in helping an agency adapt to Chevron, and now they're adapting to the absence of Chevron, and I think it's a big change in both instances. Let me just mention one other thing in passing, and forgive me for the self-citation, but there is a report on agency notice that I did with a colleague, that the commission ACUS put out about a year or year and a half ago, and I think it indicates that many agencies assume that the preamble is sufficient notice to the regulated community. And while preambles in the Federal Register do that to some degree for big companies that can pay advisors to read the Federal Register, I think we should probably cross-site to that report and acknowledge that there are many other devices that agencies have developed, including, for example, things as simple as batch emails that can be used to provide notice, but that just writing a regulatory preamble in the Federal Register is not, according to the work that we did and that the ACUS endorsed, is not sufficient for many users. So I think we need to be careful that while providing notice is one of those functions, it's not necessarily sufficient. Insight to the ACUS recommendations about notice.
Okay, thanks, Don. Bill, I know you're technically up next, but I wanted to ask Kristen to remind me when you're hopping off, Kristen.
Oh, I'm hopping off in 8 minutes, so
Okay,
let Bill go
if
first,
it's
please.
okay. Oh,
Yes.
I was gonna
Let Bill go
okay.
first, please.
Okay.
Well, I'm sorry, but I've been getting cut off from the Zoom thing every couple of minutes, so I don't know if I'll even be able to finish my short comment, which is, and I don't know what everybody has said, but it's clear to me that this recommendation should be about trying to write a preamble that helps you survive judicial review. And therefore, the introduction to the recommendation should make that clear that that's what we're doing, that this is not everything about preambles, which like going individual line by line explanation of what's in the rule is important, all right, but that's not for judicial review. That's what this is all about. It's about protecting judicial review, and we should just make that clear. And I think, you know, Loper Bright's part of it, but it's not all of it. So I don't think we should say it's just responding to Loper Bright, but it's one of the things we're responding to. Thank you.
I stand corrected, and I agree with Bill's point on that.
Okay, Don, we're gonna retroactively recognize you to make that comment. Kristen, did you still have a comment?
Yeah, just very briefly, you know, I want to echo in terms of agreeing that we need to pull some more case law references into the preamble to the recommendation, but I would add, in addition to Loper Bright and perhaps MQD, wages in White Lion, which is mentioned in the report and which I think is something that is implicitly reflected in the recommendations themselves.
Okay, thanks. That's helpful. Bill, while we still have you on Zoom, I was wondering if we could actually talk about the comment that you made about rule rescissions and severability in recommendation 9, because I was actually wondering if recommendation 9 was keyed off of regents and actually had wasn't really making a severability point, and maybe that comment could be solved by adding regents into that case law discussion that comes in the introduction. But maybe Dan can first tell me if I'm right about that.
Yeah, so the last two sentences of recommendation 9, which were the same in my draft report recommendations, were meant, I think, in a poorly written way to capture basically State Farm and Regents on alternatives, specifically the alternative of, you know, keeping part of the thing that you're rescinding in whole. That was my intent. I do take the point that they could be rewritten more clearly along those lines. But I do think it's important to keep, I mean, those are really the two cases we have from the Supreme Court on alternatives are about, you know, rescinding whole programs and not thinking about keeping individual pieces of them. So I think we should keep something about that in the recommendations. Would be my view.
Okay, thanks, Dan. So, Bill, not to put you on the spot, but if that's the intent and the recommendation is sort of revised to more clearly reflect that intent, does that solve your concern?
Well, I thought that it should not be in recommendation number 9 because it was responding to alternatives, and I think that's different. It's closer to recommendation 10. That's when you're changing policy. If you're rescinding the rule, that's usually a matter of changing policy.
Oh no, I think we tempted fate. Okay, so unless we get Bill back, I think we'll take that comment as to recommendation 9 or potentially incorporating it into recommendation 10 back for the next round of revisions. I want to do one last call for general comments, and then if we don't have them, maybe Kaja, we can put the recommendations up and just go recommendation by recommendation for general comments. Ron?
Hi, everybody. I'm sorry for arriving late, so maybe the point I'm about to make has already been touched on. But it struck me that the recommendation ought to say something about the extent to which this advice applies to guidance as well as notice and comment rulemaking. It doesn't speak to that. I think the answer in concept would be, to a large extent, it would. Maybe not completely. But I think the conference ought to stake out a view on this and clarify the extent to which that's what they intend to do. The only thing that I think would clearly have to be massaged is that when the report, the recommendations say you should train people to address whether the rule is consistent with the statute. You would now have to change it to say whether the document is consistent with the statute and the regulation that it purports to implement and so forth. A simple change. And maybe Dan or the group think that there's other ways in which we'd want to specify inapplicability to guidance. But I think that's something that we shouldn't be silent about.
Okay, thanks, Ron. I feel like the only thing more controversial than Alan's title recommendation is broadening the discussion to guidance documents. So I want to do one thing, which is get Dan Deacon's view on the scope, in scope, out of scope question for guidance documents, and then we'll go to the title issue hopefully quickly, and then we'll go on to the recommendations.
Well, I guess I would add to Ron's complication by saying guidance documents, but also much of this is relevant to the explanations that agencies are giving in adjudications when they're making policy through adjudication. And I mean, the report talks about cases like Fox Television, which was a adjudication case, but is relevant, obviously, in the rulemaking context. I was thinking of this as, yeah, these are pretty. A lot of these obligations are trans procedural, I guess is the word, in that they really attach anytime an agency is making a discretionary choice among, well, the arbitrary and capricious review parts apply anytime an agency is making a choice among alternatives available to it. And then the statutory interpretation pieces are really applicable anytime the agency is interpreting statutes. I was always, even though they do have that trans procedural application, I was, just because of the nature of this project, always thinking about them in the context of rulemaking. So that's sort of like where my mental energy was spent. And, for my purposes, if I was told, like, does any of this apply differently in the guidance context? Like, I need to think about that, I suppose, just because, my focus was what my focus was. But I do think it's true that a lot of this stuff applies whenever agencies are doing things of a particular kind, as opposed to acting through a particular kind of procedural mechanism.
Okay, thanks, Dan. So sorry, I think what we're going to do is, Kristen, I'm going to ask the committee staff to turn Alan's suggestion to a red line suggestion for next time, and we won't talk about it while you're gone, and we will talk about it next time. Okay, great. So Ron, did you have a comment in response to this?
I was just going to react. I think these are different
documents.
I was just reacting to Dan's comment. I think adjudication is potentially different enough that I would think you'd probably want a footnote saying some of this probably applies to adjudication, and we aren't telling you how much. In the case of guidance, I think it's much closer, and so you might do the same. I'd be open to that idea, but it might be that you could say really a lot of this applies directly. If you don't want to get into that complication, you can take the same weasel out that I just suggested in the case of adjudication and call it a day.
Okay, thanks, Ron. Courtney, you were up next.
So I don't know every single agency out there, but I've worked at quite a few. And as a general matter, guidance doesn't have preambles. It just doesn't. I mean, interpretive rules do, but guidance is usually just the policy. It's like a discussion, just saying this is what our thing is. It doesn't have like a rule has the preamble and then the reg text. A policy or a guidance document typically does not.
Thanks, Courtney. Kaja, did you want to jump in?
Yeah, I just wanted to say a couple of things. The project as it was approved by the council applies just to proposed rules and final rules. So I don't know that we could expand it to include guidance, but I also would suggest, if the committee thinks this is a viable project, that it's a separate project we could always take up in the future. So I defer to that, to the committee on that.
Okay, thanks. That's really helpful context. Don?
Yes, I was going to suggest what Ron described in less than endearing terms as a big cop-out, but I do think that that's a wise approach. I don't think we as a committee are necessarily the best committee to consider these issues outside of the context of judicial review. So there may be a jurisdictional issue, but in any event, we're not going to spend our time considering how everything might be adapted to guidance or how it might be adapted to adjudication. And I remind everyone that those are trans-substantive categories, but there's a lot of variation among agencies on those things. So I think the footnote where we say, many of the principles may apply in other areas, such as adjudication and perhaps even guidance. But we have not, as a committee, tried to adapt those specific recommendations, and that specific recommendations only apply to proposed and final rules. So I think we can kind of have our cake and eat it too. But just we really probably shouldn't waste a lot of time thinking about how we would adapt this to other contexts. So I think it's enough to do proposed and final rules. So that's my thought.
Okay, thanks, Don. So before we move to the individual recommendations, last call for comments along the lines of Dan Walters' comment about kind of broad categories of things that we should add to the introduction to the recommendations. So that comment was about kind of a little bit more background on the case law that's driving the recommendations. Is there anything else along those lines that folks want to suggest? Okay, then can we put the draft recommendations up? Okay, great. Let's start with recommendation 1 and ask if folks have more higher level reactions to this, whether content should be in or out versus very specific wording changes, which can be proposed a little later on. Alan?
Oh, I noticed in recommendation number 1, the word consider is not there, and the word consider is in a bunch of other recommendations. And it seems to me that we don't have to tell people they should consider doing these things. If we think they ought to do them, we ought to take consider out. And so I'd like to have a discussion about that general topic now. There's at least one place where the word consider is in there, and I think it's okay. But I don't mean to try to edit them all at once. But I'd like to have a general discussion about that topic now, if we can do that, because it comes in all of the recommendations, and this absence of the first one strikes me as being a reason to worry about the other ones after that. Thank you.
Yeah, okay, Alan, thanks. I think that's a super helpful flag. I want to go to Dan Deacon first because I had read the absence in the first sentence to be intentional, but I want to ask him to confirm whether when he was drafting these in the report that the use of consider or the absence of it was intentional.
Yeah, so I mean, generally I was using consider to capture kind of the caveat that I gave at the end of my presentation earlier, which was that, in easier cases, in cases where an agency's authority is well established, I don't necessarily think all the recommendations are things that agencies always have to actually include in a preamble. Rather, they're things that should be on their mind about whether to include. So that's sort of why I was using consider generally. I suppose the absence was intentional in that first sentence of the first recommendation. I think if there's a matter of statutory interpretation now, the agency gives its best interpretation under Loper-Bright. And the only caveat there is if it's a matter of statutory interpretation, I suppose.
Okay, thanks, Dan. Maybe I'll just add one comment that there might be ways we could cut down on the use of consider when we're using it to make it optional versus as a verb to mean think about, and it's not optional. So it'll be super clear when we're using the word why we're using it if we continue to use it. So more comments on Alan's general point, Ron?
I've been on this committee a long time, and I've heard Alan make that point many times. But I think the context is different from when he usually makes it. He usually makes it in the context of saying, God damn it, ACUS, take a position. Don't waffle. But in this instance, I think the various recommendations are saying it is our firm recommendation that in the individual case, the agency should consider certain variables. I think it's a different type of use of consider, and it seems to me an appropriate one.
Okay, thanks, Ron. I just want to make sure I heard you correctly. Was it seems to you it's an appropriate one or it's inappropriate?
It's appropriate.
Okay, great.
Affirmatively.
Thank you. Thank you. All right. Are there other comments? Dan Walters?
Yeah, I think Bernie raised this, but I wanted to flag it here. I was a little troubled by the inclusion of dictionaries as an example of the kinds of tools that you might use for textual analysis. I would think it would be just as fine to just take that out. I think leaving it somewhat vague as to what are the tools that are most relevant to statutory text is fine, and dictionaries are pretty problematic, even to textualists. So I wouldn't open that door to a fight on that, or any confusion about that, or any misperception that in some way the ACUS would be endorsing the use of dictionaries as like best practice for textualism. So I would just strip that language there and just leave it a little bit more vague.
Okay, thanks, Dan. I think we have that on the table in the red line. Don, did you have a comment on Alan's point about should and consider, or did you want to make a different comment on recommendation 1? Oh, you're still on mute, Don.
Different comment on recommendation 1, the language of recommendation 1. I don't have a view on consider.
Okay. Since I don't see other hands up, let's go with your comment then, Don.
Yeah, I'm not sure about taking dictionaries out. I don't have a view on that, but it does. I do agree with the last sentence about considering statutory structure and statutory purpose and so on. However, I think that the history of implementation is a very important point, in part because one of the few factors that the Supreme Court has indicated that it specifically will consider is the notion of consistent interpretations. This is in Bondi versus Vanderstock, which was decided actually just exactly a year ago today. And it says, while courts must exercise independent judgment in determining the meaning of statutory provisions, the contemporary and consistent views of a coordinate branch of government can provide evidence of the law's meaning. So I would probably think we should get the notion of whether or not there have been contemporary and consistent views into this, and maybe cite to Bondi versus Vanderstock. I do know that agency lawyers are anxiously thinking about how do they write preambles in the wake of some of the recent Supreme Court decisions. And whether we agree with them or not, the factors that the courts, I mean, they're on the Supreme Court and we're not. So, I think the factors that the court has looked at, we should encourage that agencies address those factors. And so I cite the Bondi versus Vanderstock factors as one specific one, but the comment is more general that if there are others that figure importantly, and I think this is also the case when we get to the major questions doctrine, because they have indicated a number of factors that are relevant. And typically in administrative law, as everyone knows, courts tend to base judicial review on the administrative record. So if the potential effect, competitive effect or whatever monetary effect is relevant to whether or not they would invoke the major questions doctrine, at least agencies should consider, Alan, whether or not they want to make an argument that it doesn't satisfy those criteria, but that's a discretionary decision by the agency. But I do think we should mention the factors that the court uses and urge agencies to address those factors. I think there we actually would play an important educational function.
Thanks, Don. So I'm going to ask Dan Deacon a question. So we have recommendation 4, which covers consistency. And so I wanted to ask you, Dan Deacon, if I read recommendation 1 to be a recommendation about kind of like I don't know how to shorthand this, but sort of like just reading the statutory interpretation, and not to be like an umbrella recommendation that's supposed to cover everything that comes next. Is that right?
Yeah, that's how I was thinking of it. So I was thinking recommendation number 4 was sort of the consistency recommendation. Now, of course, it seems like the Supreme Court thinks that consistency is relevant to what the best interpretation of the statute is. The court says that in Loper-Bright, so it's not logically wrong to marry it with recommendation number 1, but just in terms of readability, I suppose I had sort of separated out those two in my, in the recommendations in the draft report.
Okay, thanks, Dan. So Don, with that in mind, does that change your view about recommendation 1?
Slightly, in the sense that I had misread recommendation 1 as being a more general recommendation, because it starts out by talking about on statutory interpretation. If it's narrower, maybe if we were to say, in addition to the text of the statute or something like that, to make it clear that we're talking about a relatively more limited role. But I thought this was our general recommendations, particularly when they talk about the full range of interpretive tools. So that seemed to me to be general. So, but I don't care whether it's in recommendation 1 or recommendation 4. If you think it fits better in recommendation 4, I would just tinker, and maybe the Committee on Style can just consider tinkering with the language of recommendation 1, so it is not misread by others in the way that I did, which is that this, on issues of statutory interpretation, you could say right after that, in addition to the language of the statute,
Okay, thanks, Don. Don, this discussion has prompted, I guess, a suggestion from me, which is, and Dan, I want to get your views on it. It seems to me like we could make recommendation 1 just the first sentence of that recommendation, because that is, I think, the overarching point of this whole document, and that might also make it clearer that everything that comes after is a more specific scenario in which what the recommendation is discussing is relevant to potentially relevant to the best interpretation in any given preamble. I think we need a new, oh, I'm sorry, I didn't mean to delete the rest of recommendation one. I just meant to separate it into two. So like 1A and 1B. Obviously those aren't the real numbers, but that's what I was doing in my head. So we need a new, I think, a new bit of context at the start of the new recommendation. But is that consistent with what you were going for, Dan Deacon?
Yeah, I think that makes sense to me.
All right. And that maybe, although maybe it being too hopeful, might also solve some of the issues behind Don's comment. Don, is your hand still raised, or is this a reaction to my suggestion just now?
No, it's intended to come down automatically, but it's not coming down. So
Okay.
let me see
Okay.
if I can take it down manually somehow.
Okay, no worries. Do folks have any reactions to what's on the table for recommendation 1 based on the discussion so far? And if not, we will move to recommendation 2. Okay, great. Can we scroll down a bit then? All right. Are there comments about recommendation 2? Again, kind of general, at a more general level of should this be in or out, or should there be general revisions? Dan Walters?
Yeah, the only part of this that really stuck out to me and gave me concern was the bit about more specific delegations of authority versus general grants of rulemaking authority. I mean, I connected the dots with the report, and I think this is responding to Kristen Hickman and Amy Wildermuth's article where they try to draw this distinction between different types of delegating language. And I understand why Dan talked about that. It's an important article. And with due respect to Kristen, I do think it's a little bit out there, though, in front of the courts and not necessarily totally descriptive. And I just wonder if it's appropriate for ACUS to be taking this position, particularly when the courts have not actually specifically said this is how they're going to think about different types of delegating authority. I mean, I think it's a hypothesis about what Loper might require or how it might work, but until we have more certainty there, I'd be a little hesitant to recommend that agencies do anything with this distinction. So I think I would try to take out any part of this recommendation that relies on that distinction. I think a lot of this recommendation doesn't rely on that distinction, but there's a bit in there that does.
Thanks, Dan. Alan, did you have a point on what Dan just said? If not, I want to, okay. Ron, do you have a reaction to Dan Walters' comment? I think you're on mute.
Is that better?
It is, yeah. So just checking that your comment is on this discussion. If not, I want to
Yes,
give
it
you.
is. Yes,
Okay,
it
great,
is.
great. Thank you.
And the issue that Amy and Kristen raised is whether you can use a generally worded general rulemaking cause as a basis for treating it as a delegation. And here, the context, which is a thesis that I don't really think I find helpful, but this is different. This is saying you should put more emphasis on specific provisions than general provisions. And it seemed to me that this is just getting close to being too banal to dwell on. I mean, if you've got specific authority, of course you're going to rely on that as opposed to general authority. Just as if you have clear text, you're going to rely on that as opposed to a vague textual provision. It's almost too obvious to be spelling out in this way. I think I read the corresponding language of the report, and I think what the rule drafters were basically saying, or they tell their colleagues, is use these authorities in the most persuasive way possible. And of course, you're going to use the specific language if you've got specific language that helps you. If you don't, you can use general language. And whatever you've got, you should deploy. But I don't understand the primary reliance point except as stating something that really nobody could doubt, that if you have specific support, you're going to use it as opposed to less specific support. So I would not, I don't see a reason to draw the distinction here.
Okay, thanks, Ron. I think Nick Bagley might have a reason, so let's go there.
I just wonder if Dan Walters's concern would be mitigated by just taking, by saying the agency with authority over the matter in question. I think that gets to where Ron was saying, which is you've got specific authority over a particular thing. We don't need to get into a big debate about words or phrases. But I'm kind of with Ron. I think it's a modest. Yes, agencies will rely on the best source of their authority. I think that's all this is saying. I'm not going to get into a knife fight over exactly how to phrase that.
Thanks, Nick. Can you just state again the edit that you're proposing
let me actually just ask it as a question to Dan Walters first, which is your concern mitigated if we just took the words the particular word, phrase, or out?
Yeah, I'm not sure that's actually what I'm most concerned about. I think it was actually the part where it says should consider placing primary reliance on statutory provisions. So, I mean, to me, like I hear what Ron is saying, that this might just be sort of like, well, if you have both, you might just kind of emphasize the most specific authority you have. But to me, that language placing primary reliance seems to suggest like a normative or legal kind of evaluation that this is, the stronger basis for, agency action under a delegating statute. And I'm not sure that's always true, for one thing. I mean, I think sometimes, agencies are on pretty strong grounds for acting under a general delegation of rulemaking authority. And maybe the specific authority actually complicates the matter or isn't quite on point for what the agency is trying to do. And, it would be sort of bad, I think, to encourage the agency to, forego making the obvious argument under a general grant of rulemaking authority to try to just fall back on something that's more specific, but maybe not, kind of directly on point for what the agency's immediately trying to do. So I guess all of this is just to say, I don't know that this distinction that's being drawn in this article is on point with where the case law is, and I would be hesitant to encourage agencies to always go with the specific or the general without a lot more context. Sometimes I think agencies really are going to be on stronger grounds moving forward with general grants of rulemaking authority, and it's to be determined whether the courts are going to have serious problems with that kind of tact by agencies. But yeah, I don't. Maybe I'm misunderstanding what Nick is suggesting about the language, particular word, phrase, or matter in question. But I don't think that's the real concern that I have here.
Okay.
Okay, thanks, Dan.
I was trying to address that, so I'll withdraw my suggestion.
All right, I want to give Dan Deacon a chance to weigh in, but maybe if folks, including Dan Walters, might have a more surgical edit to address the concern that that might avoid kind of rendering the recommendation a little bit I don't know, ineffectual, then that would be good. But Dan Deacon, did you want to weigh in?
Yeah, so it's certainly that this recommendation wasn't meant to endorse the Hickman and Wildermuth article to the extent that which I think they come close to saying that this should be sort of a dispositive consideration in all cases. I tend to think, well, first of all, I tend to think, like I said at the beginning, that we don't know the answer to a lot of these questions. So I do agree that we should avoid giving the impression that ACUS has greater certainty or we have greater certainty than we have. But I do think it's, along Ron's lines, like it strikes me as quite relevant and should be quite relevant if the agency can point to language that pretty clearly invests it with authority over the particular thing. Like I have this footnote in the draft report on this somewhat almost kind of funny delegation to the Secretary of State about passports, where it uses like the secretary has authority like 3 times in this one provision. And it seems to me like to the extent agencies have that kind of thing, this is just meant to say, because one thing that I heard from interview subjects was back in the Chevron days, maybe, 15 years ago, 20 years ago or something, we wouldn't necessarily like search as hard for these kinds of things, or like we just kind of like go with the general grant of rulemaking authority and know that that would be kind of good enough. And this is just meant to say, like, to the extent you think you've got a more specific thing, courts are going to find that, I think they're going to find that relevant, even if not always dispositive. I agree with that. As far as an edit, I wonder if instead of placing primary reliance, we could just say like should consider invoking, something like that. That would sort of make sense to me, and maybe avoid the idea that we think that this is like a, has some hierarchy in all cases, that agencies should be following. I see I've provoked some hands with that suggestion, so I'll stop.
Okay, thanks, Dan. I might also exercise the prerogative to, along with Dan's suggested edit, to suggest replacing as opposed with in addition. And then Dan Walters, you were up next.
Yeah, I like those kind of surgical edits that were just suggested, but I also just wanted to react just to the call that you had earlier, Kirti, for suggestions for language that might, strip some of this reliance on specific versus general while still preserving something in the recommendation. I mean, why not have this recommendation focus on the categories of delegations that were sort of flagged by Loper-Bright, that don't use the terminology specific or general and don't even seem to map directly on to that distinction? I mean, there are specific kind of categories, or they cite cases in Loper-Bright as examples of delegations that would be respected. Maybe this goes back to the earlier comment that I had about doing more in the preamble to the recommendations to kind of walk through some of the case law, including Loper-Bright, including those really relevant paragraphs on delegation, right? Because you could have recommendation too, instead of focusing on specific versus general, to sort of say, as you're trying to figure out whether the best interpretation of a statute is that delegates the discretionary authority to an agency, you might consider analogizing to the categories in Loper-Bright, and sort of do some work to sort of flesh out what those categories are. So that would be my suggestion. Move away from specific in general and more towards what's actually in Loper-Bright, kind of latching onto that to anchor the recommendation.
Okay, thanks, Dan. Ron, you were up next.
Yes, I was going to suggest changing the opposed to, but you already did that, and I agree. And I think you could also say insert where available right before that change. So what you're saying is you rely on specific language if you've got it, in addition to general authority. And I think that probably avoids prioritizing, but it reminds people that in the Loper-Bright era, the general impressionistic approach is not as helpful to them as it might have been during Chevron. As to the suggestion about quoting the three illustrations from Loper Bright, I think we should always remember that that paragraph contains the words "for example" and doesn't purport to be limiting. And so I think it might be more distracting than helpful to list the particular ones because it might be interpreted as referring to the only situations, which is not what I think we want to say.
Okay, thanks, Ron. Alan?
When I raised my hand, it was principally to make the where available point that Ron made, but maybe we can now decide to take the word consider out, given everything else we've done in this particular. But I want, on that regard, I didn't appreciate Dan's point that he did make, that we don't want to be in a position of judging the legality. That is, that don't get ahead of the court in terms of what it's requiring as opposed to what it's advising. And so on that particular one, I think we've reached the right middle point. But we'll come back to this as we go through the other recommendations on the consider. Thanks.
Okay, thanks, Alan. I have one question for Dan Deacon, actually, which is I thought the comment about I thought the explanation of what agencies had done before and kind of generally invoking general provisions and thinking that was enough and needing to kind of course correct, needing like that this would be a value add to agencies to kind of have that reminder out there for the first sentence of recommendation 2. I found that helpful. I'm just curious if for the second sentence, and I guess second and third, the kind of more Loper Brighty sentences, your conversations and research indicated that there is something that agency drafters could really use guidance on more than just the language of Loper Bright itself.
You're asking in a way, are the second and third sentences doing anything
No,
useful?
I feel like maybe the way to put it for all the academics is like, is recommendation 2 really 2 recommendations?
Oh, okay.
But
How I understand. Yeah, I mean, I'm not particularly wedded to it being 1 versus 2. When you were saying, actually, when I thought you were saying, are those useful or necessary, I was sort of questioning that, but I actually don't have strong feelings on whether they should be broken into.
Yeah, I mean, I might have been saying both, which is what is it that we're trying to help? What helpful thing are we trying to tell agencies with those last 2 sentences that they don't get from reading Loper Bright? And telling them to read Loper Bright might be the helpful thing, so that's fine. But yeah.
Yeah, I mean, I think it's just reminding them that Loper Bright, at least on its face, although this becomes a little bit less clear, I think, in 7 County, actually, Loper Bright, at least on its face, says whether an agency has discretionary authority is a matter of statutory interpretation. So it was just, it was, I suppose, reminding them of that part of Loper Bright. I don't know if that part of Loper Bright is sufficiently hidden or something that it's useful to have that in, but that was the intent.
Okay. That's helpful. I might put a suggestion on the table to put the second and third sentences first, so that that's the general point, and the very specific point is then subsidiary, which feels minor, but at least makes it make more sense to me. Dan Walters, you're up.
Yeah, to the extent that those 2 final sentences of recommendation 2 are just kind of restating general principles from Loper Bright, and we wanted to break them off in some way, maybe the right place to put them would be like in what is now in the red line version, recommendation 1A, and then just expand a little bit in recommendation 1A, because already you didn't label it 1A, but I guess I improvised there. Just the sentence, on issues of statutory interpretation, the agency should use regulatory preambles to articulate and defend what they understand to be the best interpretation of the statute. That's very Loper Brighty as well. It's just sort of a statement of the the basic obligation that agencies have to pursue the best interpretation of a statute, you could just add a sentence there that says something like, sometimes the best interpretation of the statute per Loper Bright is that the agency has delegated discretion, and then copy and paste those two sentences from recommendation 2 at the end of that. And then that just is kind of a very black letter statement of what the law is. And whether that's helpful or not to agencies when they can read the opinion, I don't know. But it just struck me that that kind of division that we were working with on recommendation 1, might be a good place to just put like as black letter of a statement of the law as we could, and relocate some other things from other recommendations as necessary to make that happen.
Okay, thanks, Dan. I want to go to get Dan Deacon's reaction to that, but I will just say my reaction to that was that I thought the single sentence recommendation 1 was really boils down to, please put your statutory interpretation theory into the preamble, like agnostic for the purpose of recommendation 1 about what the statutory interpretation theory is, and then every other recommendation is about kind of how to make specific iterations of different statutory interpretation issues clear. And my reaction to this proposed edit is that maybe that gets diluted a bit, but having put that out in the universe, I'll go to Dan Deacon.
Man, it's hard to react in real time because I found myself agreeing with Dan Walters, and then Kirti made me think maybe it wasn't such a slam dunk. So I'm not sure. It kind of made sense to me what Dan was saying there, that this does seem to be kind of like a pretty general, just almost like copy and paste job from Loper Bright, such that if we were starting with that kind of thing in recommendation 1, that kind of made sense to me. But hearing the pushback on that, I don't feel strongly like one way or another about it, I would say.
Okay, why don't we see if anybody else has comments on that last proposed change? And if not, Kaja, unless you disagree, I might suggest we take a 10-minute break now. Okay. Then let's do that. Let's take a 10-minute break and come back at 1:49 Eastern. Okay, great. I think that we have enough food for thought on 1.5, and 2, such that we can move to 3. Though if there's a rash of hands raised in response to my saying that, we can entertain that. So if not, let's go to recommendation 3. And again, ask for general reaction. Should it be in or out, or kind of high level suggestions for revisions? Okay. Hearing, oh no, Alan?
It's a low level reaction. It's consider, and I don't understand why I think we should recommend that they use the preamble to explain why the party's resolution supports the agency's determination.
Dan Deacon, does that align with the intent behind the recommendation?
Yeah, I mean, it's another situation where could we come up with, could we imagine circumstances where the agency is using, the fact that there are underlying factual or empirical questions in a way that, it's well served already using other kinds of arguments, like there's express language, so it doesn't necessarily need to drive into the ground that this is an issue within the agency's discretionary authority. That's again just why I was using sort of consider throughout, as I think you could often imagine situations where an agency doesn't need to go into so much depth on a particular issue or touch all the bases on a particular issue.
But this recommendation says where it turns on resolving the factual disputes. So that different situation wouldn't apply.
Okay, that's fair.
Yeah, can I ask I think I had a question along the lines of Alan's reaction, which is I had thought recommendation 3 was if you are exercising obvious discretion in sort of like Loper category 3, basically show your work, walk through the steps of how you did that. But it sounds like Dan, what you might have been intending is for an agency to be clear about when it thinks something is even falling into Loper category 3. But let me know if that's wrong.
I think that's right. So to me, the fact that some kind of question turns on underlying factual or empirical questions might be important for any number of the kind of branches of the Loper-Bright tree. And I think we don't exactly know yet. It could be important, as I think Seven Counties sort of indicates, to whether the agency is exercising discretionary authority in the first place. It could also be relevant in indicating that this is a mixed question of law and fact where Skidmore weight should have particular purchase. So this is a recommendation that is kind of designed to capture multiple different things that an agency could be using the sort of enmeshing of a legal and factual question to serve. If that makes sense.
So can I propose an edit and ask if the edit is consistent with that? So if the recommendation, if we deleted if it's just if a statutory determination turns on resolving, so like take the agency's belief out of it.
Okay with me.
I think that's okay.
I see Ron's hand is up. Ron, do you want to?
I would not do that. I think if the agency has formed the belief that they need to resolve these issues, here's how they should do it. But we don't need to leave it as a question that may not be certainly true at all. And so it's the agency's belief that brings this recommendation into play. Otherwise, you get to a circular argument, I think, where you have to know how the legal questions stack up in order to know whether the statutory termination turns on it, et cetera.
Yeah, that something like that is, I think, why I included that language, because a court might later disagree that the statutory determination turns on resolving underlying factual or empirical questions. But if the agency believed that it did at the time, it's still proper to have included it in the preamble. It turns out to have been included on, I suppose, a mistaken belief, but.
Okay, got it. Can I try? I'm going to try one more time and then I'll recede, which is, what about when the agency makes a statutory determination that turns on? Which is, I think, in line with it being a show your work recommendation.
I think Ron will have the same.
Okay.
Perhaps, but.
I would.
Okay, then I'll recede. Okay, are there other recommendation 3 comments? If not, we'll go to recommendation 4, which is the consistency recommendation. So again, comments along the lines of in or out or general high level suggestions. Okay.
Well,
Yeah. Alan?
do I have my standing objection on consider? I've been waiting for other people to have other comments first, and then it rises as a couple of places. It's in the next line also.
Okay.
And
Thanks.
again,
I
down
will,
85.
I'll just ask Dan Deegan as before if any of those deletions sort of materially change the recommendation in a way that you want to flag.
Oh, there's also consider on line 81. We got the first word on line 81.
Yeah, I don't know. I mean, I feel like I'm sort of interested in what other folks think about this because I suppose I have my standing response, which is I could imagine situations where an agency says this isn't worth the ink for whatever reason to go into all this detail, and that's what consider was trying to capture in most of these circumstances. Now, are there individual sentences that are written in ways that might obviate my concern and allow us to take out consideration? That's, if there are, I'm open to that.
I mean, the fact that we make a recommendation doesn't mean the agencies are going to do it. If they have some good reason for doing it, but I think that we want to encourage them to do it, and consider is less strong than encouragement than I think your recommendations warrant.
Okay, let's go to Ron next.
Yeah, I'm going to agree with Alan on line 81, but not on 80, and with Dan on 85. I think on line 81, they should explain their position. Otherwise, they're being intolerably mute. But with regard to using analogies, it might be helpful, it might not be helpful. You don't want maybe you want to respect the word concise in 553C to that extent, and not belabor things that you don't really need. And so the analogy may not be helpful overall. So I would just consider using it, but I would think with regard to 81, you should always somewhat explain your position.
Okay, thanks, Ron. I think one way to make to the reading audience make sure that they have a view into this debate that we're having now might be in the introduction to the recommendations to think about including some of the language that's in Dan's report about those competing demands on agency time and capacity, and the trade-offs, recognizing that agencies make trade-offs, and then that the recommendation should be read in light of that, and that might get Dan's standing objection across to the reader. Or standing response to the objection, I guess, to be accurate. Are there other comments on recommendation 4 about this consider issue or about the rest of the substance of the recommendation? Okay, then let's move to recommendation 5 about
Oh, can I go back to 4 for just a second?
yeah, no problem. Go ahead.
Go back. So line 87, it says give more weight. I read that and I say more than what? But I think if you used particular rather than more, you wouldn't look for the rest. You would just say, all right, especially special weight.
Okay, thanks, Ron. I'll just pause in case there are any reactions to that. And then if not, we'll go to recommendation 5. Chen?
Sorry, I don't have a reaction to that, but I had one more thing on recommendation 4.
Great.
and I'm sorry if this was just discussed, I'd step away from this for a second, but where the sentence that says in claiming consistency, an agency should consider drawing from a broad range of past agency actions, including, could we maybe say including where possible, guidance and agency enforcement proceedings, just because they, because such proceedings may not have taken place. So it could be consistency with past rulemaking actions. There may be some guidance on it as well. There may be agency enforcement proceedings, but the agency actions may not include those particular types of proceedings. So I was just trying to be clear about that.
Yeah, can I make one friendly, I think it's a friendly amendment, which is where relevant instead of where possible, because I think possibility suggests you do everything you can to rely on those documents, which I'm not sure is what we intend. Okay, great. Thank you. Okay, another pause for last views on recommendation 4. And seeing none, let's scroll down and tackle recommendation 5. And opening up the floor to reactions to recommendation 5. Do we want to start, Alan, with the
Yeah.
Yeah, okay.
Consider. I hardly, if they have them.
And Dan, if you want to say anything, you can. If not, if you've already spoken your piece, we can move on.
I guess I would say that this is one area where this is really about the major questions doctrine. I mean, it's a little bit about Loper Bright as well, but I mean, just to underscore here my standing response to the standing objection. This was an area where some agency folks that I interviewed were like, we don't really think about, just because of the nature of what we're doing, we don't really think about major question stuff coming up at all. They wouldn't be really in particular cases necessarily like racking their brains around these kinds of things. But again, if we want to put it in general language to the preamble that captures my standing response, I'm happy to go with what the general sentiment is on that.
We could put in at the end of the first phrase there, when exercising regulatory authority where the major question doctrine may arise. Because that's what this is intended to do, I think.
Okay, let's put that edit on the table in red line, and I suspect there will be reactions to that. And then Dan, you are up next.
I think Dan may have just answered my question, but I sort of stumbled over, I guess it's the third sentence of the recommendation in identifying such regulatory antecedents and precedents. The agency should consider discussing a full range of characteristics that a reviewing court may find relevant, including but not limited to the rules associated costs and burdens, its scope, and analytical method. I didn't understand what costs and burdens, scope, analytical method really had to do with past antecedents. But I think maybe what Dan just said, that this was sort of designed around the major questions doctrine, sort of helps me understand where it was going. But again, to kind of reiterate something that I raised earlier, I think in some ways, some of these recommendations would be much more intelligible if there was like a specific mention of the doctrine that was motivating the recommendation. I would not have understood that sentence without Dan's clarification here in the meeting. So just underscoring that it might be worth bringing in some references actually into the recommendations themselves or something like that.
Okay, thanks, Dan. Heather, you're up next.
Yeah. Is that something that would necessarily have to be in the preamble to use in litigation? Or, it seems like something that the agency litigation counsel could bring up in briefing in defending the rule if necessary, because it's not why the agency took the action, but more why the major questions doctrine shouldn't preclude the agency from taking that step.
Dan, I think your report touches a bit on the benefits of putting it in the preamble. Do you want to summarize that?
Not that it would be wrong to do it, but in terms of making it seem, I guess, taking out consider potentially, making it seem more.
So I think that's right. I mean, the report has one kind of paragraph on Chenery 1 and what has to be in a preamble for purposes of sort of legal questions, where I kind of just punt on that. But I do think it's right that probably this is the kind of thing that could be raised. Like, I don't think a court probably would say, well, you didn't invoke this particular precedent in the preamble, so you are barred from doing it now. I think what Kirti is referencing in the draft report is, I do say that particularly for like very complicated things with long regulatory histories, the preamble just might be, in terms of space, the best place to get in a lot of details, which then can be just basically cross-referenced by a later brief that isn't working with as much space. So that was mostly my thought for why, again, the agency should think about including this kind of material in the preamble, even if it might not be strictly necessary under Chenery 1.
Heather, did you have any reactions or follow up to that?
No, I mean, I agree. I think it's helpful. I just didn't know in terms of whether we make it seem more mandatory by removing consider, is something that the group wanted to consider.
Okay, thanks. Ron, you're up next. I think you might be. There you go.
There you go. Yeah. I think it's going to be hard to capture the essence of the major questions doctrine in a recommendation like this. And just to illustrate, not to get the debate to too specific a level, but as I read the report, Dan downplayed the economic impact aspect of major questions much more than I would have expected relative to the novelty point. I think that was influenced by the Revesz and Brunstein article, which I think had an agenda for giving that interpretation. But I think in reality, it's a much more important variable than you can see in this paragraph. But really, I'm not saying, okay, let's crowd it up even more. I'm saying cut it down, because we can't really capture all the aspects of the doctrine, let alone the ones that will emerge 2, 3, 5 years from now. And just say in more general terms that if the major questions doctrine may be implicated, and I agree with Don, that has to be spelled out so that we know what we're talking about, then you should bring out information or arguments and precedents that would be germane to that determination, and not say a whole lot more.
Okay, thanks, Ron. Heather, I just want to make sure that your hand is just still up from before.
Oh, yeah, sorry, I forgot to lower it.
Okay, no worries. Then Dan Deegan, if you had any response to that comment.
Yeah, so I guess I just clarify that this recommendation wasn't necessarily designed in order to cover all of the agency's bases or to provide the agency sort of comprehensive response to a major questions doctrine argument. I think I was viewing and this sort of goes to Heather's question and my response to it. I was viewing this aspect of the major questions doctrine, that is novelty, as an area where the preamble can be of particular usefulness, I suppose, both to the agency and to the court in understanding whether this is novel. I don't go as far as Revesz and Brunstein and thinking that, I think they say this is basically like a necessary condition of the major. I don't think we know that. I do think it's been an important consideration in the Supreme Court's case law. And the reason why the recommendation focuses on it is, like I said, it seems to be the thing that the agency has the most control over for purposes of the preamble, and how it discusses things in the preamble. Whereas costs is kind of like there are probably some things an agency can do, maybe things that we wouldn't want to put in an ACUS thing about, splitting rules and stuff like that. But for purposes of an agency explanation, this is kind of what I thought the preamble could be best used for.
Okay, thanks, Dan. So I guess I had one question that I guess if none of the agency folks are raising it, it might not be a real concern, but I assume agencies are making decisions when this recommendation is relevant about whether they want to initiate a major questions discussion or even admit that they think it might be in play. And I might read this recommendation to sort of say, err on the side of accepting, even if you think it doesn't apply, or even if you think there's some chance it might not come up, or that if it comes up, it's frivolous, to do the work anyway. And I would be curious if other people had that reaction, or not. Alan?
Well, I think certainly by the final rule, the agency will know whether somebody's going to raise the major question doctrine. And I think it's better. These are useful suggestions, and I found them particularly useful because they're specific to tell the agency what to do. And I can't imagine that any of these things would be harmful to the agency's defense of the rule in any event. And so I think we're not saying where the major question doctrine. It just says where arises, and I think that leaves the agency discretion, not to think it is. I found this useful. I wouldn't worry about the suggestion, the concern that you had, Katja.
Okay, thanks. Ron?
I think I agreed with Kurt's point, and so I would just tinker very little bit at the outset to say, in substance, if they decide they want to address the possible application of the major question doctrine, then blank. Alan may be correct about what would happen, but I don't see why we want to put a thumb on the scales of saying, be sure you touch on it. But if you do want to touch on it, here's an explanation of how.
Thanks, Ron. Don, you're up next.
Yes, going to the point about the agency being reluctant to raise the major questions doctrine, because that suggests it might be applicable. I have detected that in some conversations with agency folk. And so I think a good approach on that might be to say, if the major questions doctrine has been raised in the comment period, the agency should develop a record bearing on the factors indicated by the case law. I think that the good point that Ron made, that the law in these areas is likely to continue to evolve. And I think for that reason, we should be very specific about citing the precedents that we are referring to, because they may not be the rule forever. And I think it's helpful to people subsequently to see what we had in mind. That's it. And now I'm going to try and figure out how to lower my hand.
Okay, thanks, Don. So I think my screen's a little zoomed in, but I think we might have kind of a standing question on the table for the committee staff to consider about whether, in addition to the additional background and the introduction to the recommendations, specific recommendations should have case citations. So I don't think we need to discuss that more today, but I just want to make sure that, because that's come up a couple times, that that's preserved for the revision period. So there's some language in here for that can be kind of workshopped during that revision period. It does seem to me that if we go with if the major questions doctrine has been raised in the comment period, we might need to delete the sentence about NPRMs, unless we're just assuming there was a like RFI or something before the NPRM. but I think we can. Dan?
Yeah, so I mean, when I was talking to agency folks about this, I mean, typically they're in the preamble to the final rule talking about the major questions doctrine because it's been raised in the comment period by somebody. That's usually what they're when they're going to be addressing it, at least by name. That said, I do think you know, in a different article, Ricky Revesz talks about the potential importance of developing and flagging antecedents in the notice of proposed rulemaking in order to see what folks have to say about them, in order to see if anyone brings antecedent to the agency's attention that the agency wasn't aware of. So I'm a little bit, you know, just personally to say it should only be if it was raised in the comment period, even though that's kind of the most common, I think, time an agency would be doing this, again, especially invoking the major questions doctrine by name. I still think it could make sense in some notice to proposed rulemakings for agencies. Maybe they don't want to say, we think there's a major questions doctrine problem here, but they might want to say, listen, like, what have we done in the past that has been relevant or that looks similar to this? Here's what we think. We'd accept folks' comments on that.
Okay, thanks, Dan. Chen, you're up next.
Yeah, so speaking as agency counsel, so I would say just in general, the substance of this paragraph, I have, this all makes sense to me, but I think if we are going, and I understood that the recommendation was going to the major questions doctrine, but I think that if we are going to specifically reference that because, obviously because it's still evolving, maybe the committee should consider giving agencies a little bit more flexibility here. I can't really think of a circumstance under which an agency would not want to address these issues, if major questions was raised in the comment period, but I also, don't know what might happen in the future. And I know, so I would like to see a little either, if we specifically reference major questions doctrine, I would like to see if folks might consider putting the word consider back, which I know is a whole another area of debate. But I would just like to see I would just like to see this recommendation give agencies a little bit more flexibility.
Okay, thank you. Alan?
Well, I won't say the agencies have got as much flexibility as they want. ACUS has no troops, can't enforce the rules. But I want to take up Dan's suggestion, which is why I raised my hand, which is I think we should take the sentence about notice of proposed rulemaking stage and move it to the end, and then say, in addition, at the notice of proposed rulemaking stage, if the agency believes that the issue may arise, I haven't got the right words, but to say something along that at the end of the sentence to give them to make it clear that this doesn't apply at every stage, every case, but we at least want to think about it because it may be to the agency's advantage to see whether others think that the notice of this is a major question case, so that they can take care of it in at the end. I'm sorry I don't have better language for that, but.
Okay, thanks, Alan. Don, you're up next.
Yes, I was thinking along the same lines and was going to offer as a friendly amendment the idea that if the major questions doctrine is raised either in the notice of proposed rulemaking or in the comment period, the agency should develop an appropriate record bearing on the factors that are then relevant in the case law. So that's my suggestion.
Okay. Thanks. I guess just to throw maybe a wrench into this, I guess as a litigator, I want to know, regardless of whether the major questions doctrine is in play, if there's some really clear past agency action that resembles the rule, like that's just helpful in regular old statutory interpretation. And I also maybe have some concerns about naming the major questions doctrine in those terms for getting through the voting process. And so I wonder if recognizing Dan Walters' earlier comment about, trying to be clear, and this might be inconsistent with that, but I wonder if the first sentence could be when an agency exercises its regulatory authority in a manner that resembles past agency actions, it should use the preamble to identify and discuss those past actions. And it could probably be more elegantly worded, but that's the gist. And then I think we would have to lean on the introduction to the recommendations to discuss the major questions of it all. But are there reactions to that suggestion? Alan?
Do you mean to not include the mention of the major question doctrine? Because I thought that somebody's point earlier that telling us why each of these recommendations is relevant to some of these issues was helpful with people understanding why it was. So I don't have I'm not concerned about the specifics, but I think it is on balance more helpful that we reference the major question doctrine and the other doctrines that we're talking about. I mean, for example, in the one before where facts turns on the facts, that was perfectly clear. We didn't have to invoke a legal doctrine, but I think it's helpful to do it that way.
Yeah, my intention was to remove the reference to major questions, in part because I think this advice is applicable all the time, and it's especially applicable when it's sort of obvious there's going to be a live major questions debate. But it is still something courts would consider in just interpreting a statute without the major questions doctrine being in play. And so that was the reason for the suggested edit. And then, yeah, totally recognize that the sentence as revised, the fact that sentence 2 is a reference to the major questions doctrine jurisprudence is not clear. So one way to deal with that is in the introduction to the recommendations that is going to be drafted to reference more of the cases per a suggestion we had earlier, but there might also be edits we can make in this sentence to make that clearer as well. Dan Walters?
Yeah, I think it would be fine to not mention the major questions doctrine here, if that's going to be better for getting through the council and whatnot. But I mean, I would reiterate the concern that I raised about the sentence in line 94 that starting in line 94 that mentions things like costs and burdens, which I think are really specific to the major questions doctrine. And if you were trying to sort of couch this recommendation in more general terms without mentioning the major questions doctrine, somebody just might stumble over that. So it just might be worth thinking about whether to include, specific language in there that maps onto the MQD if it's meant to be a more general recommendation. So it's a choice. We can go either way, but just want to reiterate that that sentence was problematic to me without the context of it being MQD.
Yeah, I mean, Don, I see your hand, so I recognize I'm jumping in here, but maybe the way to do it is that would still solve my breadth issue is to add back the where the major questions doctrine has been raised at the beginning of the second sentence and replace the introductory clause to that second sentence with that language. So delete and identify. Yeah, there we go.
Sorry, can you just repeat what the edit would be?
Yeah, delete that whole introductory clause in identifying such regulatory entity. Yeah, and so then that would be where well, the prior language is if the major questions doctrine has been raised in the comment period, though I think there's still some debate about whether that's precisely
In the
right.
NPR or the comment period is what we're talking about now.
Okay. So it would be if the major questions doctrine has been raised in the end. Yeah, you've got it.
Either in the NPR or in the comment period, the agency should develop appropriate record.
Yeah, so I think the appropriate record edit is a separate suggestion, but yeah.
Oh, and you don't even try to specify what it is. You just say they need to develop it, and that'll be as the case law evolves. That'll change. You know.
Okay, thanks, Don. So maybe we can solicit comments on that specific suggestion, which I think would be to make this second sentence very generalized and say something like the agency should discuss the full range of characteristics in the relevant case law versus the list that is in the sentence now. So we'll put that on the table for discussion. Do any folks have preferences? Folks including Dan Deegan, of course.
I don't have strong views. I would say I suppose the Chin had liked the specificity, I think, of that in terms of guidance to agencies. But if we think it does more harm than good, I'm open to that.
Would it split the difference to have the introductory language, the recommendations where it discusses the major questions doctrine, list these specific items, but keep the recommendation text as a cross-reference to evolving case law?
Are you asking me?
Anyone, but yeah. Don, why don't we go to Don and then Dan after that?
And that's what I was going to suggest, is that you list the specific factors and then say, as well as any additional factors that may be required under the evolving case law. So we recognize that there will be an evolving case law, but we don't need to lose the specificity, which I think Dan or others pointed out was desirable. So maybe it's a both and approach.
Okay. I think that's a slightly different suggestion, but works just as well. So that's what's on the table now with the red line. Okay. I don't think we need the last. Do we need the last? No, we do. Okay. Okay. So unless there's anything else on recommendation 5, we can move to recommendation 6. Which is about changes in positions. Are there high-level comments about recommendation 6? Alan, are you not objecting to consider in line 107 and 110?
Well, the language is a little different there, and it's not to consider using. I think what they wanted is to seek to use evidence. If the evidence is there, I would say use it, but we don't know what the evidence is, and so that's and the same point with what's now line 110 should seek to use to provide evidence or try to or something along those lines.
I see. So would it work instead to say where available, the agency should use evidence
Yeah,
in the
that's fine.
record to
Yeah, that's
demonstrate?
fine.
Okay.
Yeah, that's better.
Um,
And
And
the
then-
same is true in addition,
Yeah.
further on down, yeah, the line 110. In addition, where available, the agency should provide evidence suggesting that the I don't need the notice you need. Yeah, okay, yeah, yeah.
Okay. Great. Are there other comments on recommendation 6? Don, are you raising your hand? Yeah.
Yes, yes. So I think evidence can be misinterpreted to be a word of art, which is not what you mean. And also in the record can be misinterpreted to get you into sort of a hybrid rulemaking because it's, on the record or, so I think those are all issues we really shouldn't necessarily talk about today, but you may want to modify the language a little bit.
Yeah. Okay. Thanks, Don. I think that's a good point. It's also
You
it
could say,
flags
for,
that.
I'm
Well, I was just
sorry.
going to say it flags that these two sentences aren't actually directed at writing the preamble. They're directed at building the record.
Right.
So I
Right,
wonder
right.
if,
That's a
or
good
do you have
reason
a
to take
suggestion,
them out.
Don?
Yeah, I was gonna say material in the rulemaking record, which would get the same idea across, but would eliminate those two words of art. So you wouldn't have the unintended consequences. But I don't have a view as to whether or not you say it at all. That's up to you. But if you want to say it, I want you to say it in a way that won't cause us big unintended problems. So I'm just trying to be helpful.
What if it's where available, the agency should discuss evidence in the record that demonstrates, and that way it's still about writing the
You see,
preamble.
in a rulemaking proceeding, you don't have a record in the sense that you're used to with regard
Yeah,
to
we could say
trials.
administrative record. I mean, there is a
Yeah,
record.
that's right. There's ambiguity about what we mean by the record. What they do in rulemaking, which is where they do most of these things that might be considered major questions, is they publish what's called a notice of data availability. So they make data available to commenters. But if you don't want to get into all that, you just say based on material, you could say material made available for comment in the rulemaking records.
Okay, thanks, Don. I don't quite know how to read Dan Deacon's facial expression, so I just want to assess your comfort level with what's happening before we go to Dan Walters.
I'm not wedded to evidence in the record, so if we want to say something, I mean, I think we could say something as general as like information or something like that. Like, I mean, I think an agency can kind of, I don't think there's like a lot of particular rules about what goes into a notice and comment preamble in terms of like the record versus not the record. So I think you could just say like stuff is probably too informal, but something like information that, yeah.
Okay, so we would delete in the administrative record.
I think you could.
Yeah. Okay.
Or it becomes part of the administrative record by the agency discussing it.
Well, in theory. Dan Walters, you're up next.
Yeah, in line 110, the edit that was made to add where available, I wonder if maybe there we should say where applicable. It's a very slight change, but I think it might be helpful or even necessary, just because there will be times, including statutes that involve delegations of discretion to agencies, where the original meaning is that the agency has discretion, that the prior interpretation wasn't necessarily inconsistent with the original meaning. So I just think it's worth caveating that quite a bit, even more than where available, to say where applicable. It's just categorically not going to be relevant in a huge class of cases. So just a slight suggestion there.
Okay, thanks, Dan. That's reflected in the new red line. I guess I have one question, which is maybe Don has just convinced me that evidence is a weird word here, but I'm not sure what evidence would arise about the original or meaning being incorrect. Like, unless it's like a new dictionary that nobody, knew about. So I'm wondering, maybe Dan Deegan, if it's okay to ask you if there is a revision that would avoid that concern, but still capture what you were going for here. Or you can tell me I'm missing the evidence that's relevant.
I mean, if I'm open to just changing that to information again, if that, I don't think the way that I was thinking about this, it wouldn't need to be new information necessarily. It could be, I don't know, a general counsel memo from a day after the statute was passed, that maybe just hadn't been taken account of before. It was sort of out there, but not taken account of, and now the agency wants to rely on that. That's the sort of thing I had in mind. So something capacious like information would work for that, if that works for other folks.
Okay. Okay, are there other comments on recommendation 6? Okay, then let's go to recommendation 7. And open the floor to general reactions and high-level suggestions on recommendation 7. Alan?
Consider.
Yeah.
I have it in, well, I get it's now line 113 and 120, I think. Oh, no, 117 and 120.
And
no, leave the 119. If they're required to consider, leave 119 in there, because that 120 is fine to take it out, but 119. If the agency were required to consider implementation costs, that's a different use of the word consider.
All right, so then we'll go to Dan Deegan for any standing response.
So I think I agree with taking out the first consider there. I do think we need another caveat in 117 if we take out consider, because the justified under alternative decisional criteria thing is, that's probably only going to be sometimes appropriate, I think. So I might, if we don't say consider, I would say if appropriate or something like that.
I don't have a problem with the where appropriate at the beginning of that sentence that Dan was just talking about. Applicable. Yeah, that's fine too. Yeah, applicable, appropriate. Applicable.
Can I ask Dan Deegan for a little bit more explanation on what this sentence is, what problem this sentence is trying to solve? Is it just uncertainty about what the statutory requirements?
Yeah, I mean, it really grows out of the discussion of how to deal with costs, which I discuss in more detail in the draft report. Sometimes it'll be unclear how a statute allows an agency to consider cost. So some agencies have articulated justifications that say basically like, under the assumption we are not allowed to take into account a cost, or we're not required to do a formal cost benefit analysis, we think this action is justified. And also, by the way, if we are required to do a formal cost accounting, we also think it's justified.
Yeah, okay, then I guess again, I would defer to the agency folks, but this, as revised, this sentence seems to say, always, if there is a debate about whether you do or don't consider costs, which, happens a lot, especially, and will happen more, I think, in the future, do both, and like doing the work to solicit that information to be able to run the numbers might be quite burdensome. And I could imagine a world in which agencies again might not want to acknowledge even that it's an option on the table. But I take the point, Dan Deacon, that some just do as a matter of course. But that's my reaction to the revision, is that it seems mandatory now. Don?
It could potentially solve that just by saying applicable and available. So they got to consider any information if it's available. I think that accommodates the practicality of things.
Yeah, I will say, for what it's worth, I'm not sure it 100% solves my concern, because agencies might have some data, for example, that they have to complete the regulatory impact analysis with, but not want to take the extra time to run the statutory decision-making framework, considering costs, if they don't have to under the statute. But if there aren't agency folks on who have that concern, I probably don't feel strongly about it. Dan Walters?
My comment's actually about the next sentence, so hold it
Okay.
until we're ready to move
Heather,
on.
did you have a comment on this sentence, or did you also have it? Okay. Do you want to
Are
go
you
then?
just with recommendation 7, and I can't remember the prior one where it was, not necessarily a mandatory discussion in the preamble, but advisable.
And sorry, Heather, did you have a edit that would reflect that?
Not other than, I guess, consider, so something to suggest that it's a recommendation, but not something that we deem must be included.
Okay, so I think the upshot of this is that really the debate is about deleting consider or not. So for now, let's leave that and go to Dan Walters. You said you had a different comment.
Yeah, the sentence starting in line 119. That sentence reads kind of weird to me. It's saying basically agency should rely on predictive judgments formed on the basis of incomplete evidence, which sounds like almost perverse advice. And I think it's actually meant to be kind of combined with the final sentence. It's sort of saying, the agency can rely on predictive judgments under applicable case law without complete evidence, but they should be forthright about it when they're doing so. So I actually would change the language from should rely on predictive judgments to the agency may rely on predictive judgments. I think that captures probably what Dan was going for. I'd be curious about his reactions, but otherwise that sentence is kind of weird to me.
Thanks, Dan. Dan Deacon, did you
Yeah,
want to?
I think it works better with May, so I agree with that.
Okay. So the consider debate is still on the table. Don?
May, where legally appropriate, rely on predictive judgments. Because there are substantive statutes that either allow that or don't.
Ron?
I just wondered whether May seems to be coming too far towards taking a position on the law. And maybe what we want to do is to say if they're going to rely on predictive judgments, then on the basis with incomplete evidence, then they should be forthright, et cetera.
Yeah, can we put an alternate sentence on the table to try and keep this red line clean, which would be when an agency relies on predictive judgments formed on the basis of incomplete evidence, it should be forthright when doing so and not claim more certainty than is appropriate.
That's the same point I was making, so I would support that.
Okay, so it would replace the sentences that it's sandwiched in between now. So are there objections to that revision? Or something short of an objection, reactions? Okay. Okay, so recognizing that the consider debate is still on the table, I do wonder if this is an area where the fleshed out introduction might inform how we think about what's in here. So I want to move us to recommendation 8 and leave that for the next meeting, unless anybody wants to demand a vote. Okay. So let's go to recommendation 8, and the floor is open for general comments or suggestions. And Alan can't make the comment here.
I do have one with respect to, not to consider, but the last line.
Yeah, go ahead.
I didn't like the phrase left viable alternative on the table. And maybe the long language along failed to explain why it did not adopt or utilize potentially viable alternative. I thought it was kind of imprecise language. That would be line 128, or has with or failed to explain why it did not adopt a potentially viable alternative.
Okay, Dan Walters, did you have a comment on that?
A separate point.
Okay, yeah. Let me just see if anybody has reactions to that language first. And then, okay, hearing nothing, Dan Walters, let's go to you.
Yeah, so the second sentence of this recommendation, identifies a number of situations in which comments would require a response, but I think it's going to inevitably be an incomplete list. I mean, as the report acknowledges, this is a really, context sensitive area of the law, and I would be more comfortable with this language if it was just a little bit more clear that this is not an exhaustive list. I know it just says including, which might imply that, there's other things, but I would just add, something to suggest that there may well be other categories out there. And the categories wouldn't even be that well defined because it's really kind of a moving target in the case law. So just something in there that's a little bit more of a caveat, I think would be good.
Okay, the red line has some proposed language, but I think I'm going to press you, Dan Walters, if there's specific revision that would, if you're fine with this, that's fine. If there's something else that you want to put on the table to address your concern, that would be great too.
I mean, I can think about it more, but I mean, one thing that really stands out would be, comments that include data that wasn't, before the agency or something like that. I don't know if that really fits into any of these. Seems like these are really more focused on, the reasoning in the comments. So focusing on, statutory language and justification, policy alternatives, things like that. But it could be that a lot of comments require some kind of a response simply because they provide some new information to the agency. That's just one category that I can think of. I'll try to put more thought into others as well. But again, I think it's such a voluminous list that it's sort of a fool's errand to try to articulate them. It's better to just have a few examples than just be really clear that this is meant to be a very short, non-exhaustive list.
Yeah, so if we said comments requiring a response include, for example, so include and for example are probably a little repetitive, but would that get the point across? Would that give you some comfort?
Yeah, for example might work, but I think something like include among other comments like you have would be good.
Okay.
At a minimum or something like that.
Okay, let's see if other folks have suggestions. Alan, your hand has been up from before. Is this a new comment? Okay, Don?
Yes, I do think that getting some further content into the notion of significant content that needs to be responded to by the agency would be a major public service. I think a great deal of time and delay goes into responding to every single comment because the courts have basically not provided any real context because they don't want to box themselves in. But there needs to be some specification, and I would suggest that comments deserving of a response should show that they are, quote, significant, which is the test in the case law going back to Portland's in that case in 486 Fed Second, but a number of other cases subsequently. So basically, you have to respond. And I think that the comment should show that if the data or policy advocated by the comment were accepted, it would make a quote significant change in the rule or regulation. And of course, significance is defined for purposes of the executive order. We don't need to get into that. But if somebody wants to argue, because otherwise it takes about 2 years, and most groups in an agency can only make 1 or 2 rules a year. And so there's a big demand, and part of that is because it's so expensive in terms of agency staff to respond to all these comments. It's not unusual to receive 1 million comments or tens of thousands of comments, and ACUS has dealt with that in terms of repetitive comments and et cetera. But I do think that trying to provide some obligation to show why it's significant, why the comment would lead to significant changes in the rules if it were accepted, I think that should be included.
Okay, I took that comment to maybe be a suggestion, not so much on Dan Walters's points about what counts as significant, but about what counts as a adequate response. So assuming that's right, if there are people with reactions to that, we should have that discussion as well. Ron Levin?
Yeah, so Dan kindly cited my far-seeing cogent article on the subject in his report. So I thought I should say something. But I would say, since this is about best practice, not about what legally required, maybe instead of using the word requiring, we should use the word warranting. So that the understanding is this is our idea of what good practice is. But, if you have an ill-reasoned comment, it may be well advised to respond to it. But this is about having a sound rulemaking and making judgments on that basis. And what you have to do in order to comply with the law is not quite the same.
Thanks, Ron. Okay, so the two ideas on the table are one, whether we can do more to broaden or indicate that the category of potentially significant comments is broader. And then maybe whether we need to say anything about what a response looks like. Don?
I actually was suggesting that the comments that are regarded as significant should be narrower, or at least they should be defined and concrete. There should be evidence-based. Let's just say they should be evidence-based. But I think right now, my experience is that the agency feels compelled to answer every single comment because it doesn't have any guidance as to what makes a comment significant.
Okay, maybe I can ask Dan whether Dan Deacon, sorry, you took as a given maybe an assumption or knowledge about what counts as significant, and this was another kind of show your work suggestion, or whether you think that you found that agencies do need guidance on what counts as significant, and we might be able to provide that in this document.
Yeah, I mean, here I was mostly going on the case law because, I was trying to ask my interviewees about a lot of different things, and comments was something that seemed so context sensitive that without a lot more time to really focus on that issue, I didn't think that the interviews really developed like where agencies were having trouble or what they needed guidance on. A lot of the folks I talked to were kind of like, I guess this does indicate that they need some guidance, but they were kind of like, we try to do the best that we can with the comments that we receive, and what's significant is kind of depends on the proceeding and the nature of the question, et cetera. I take it that maybe Don Elliott's point is, and the draft report talks about this a little bit. So there is this like suggestion in the case law that what the comments that are significant are comments that are material. That is, they might like change the agency's mind, and that means they're developed to some degree that like a reasonable person might look at them and think, oh, this actually does maybe mean that the proposal is, requires a second look. I wonder if adding something of that flavor, maybe in a new like second sentence, and then say like material comments may include those that raise X, Y, and Z might be appropriate. So the second sentence would be like, something about comments requiring or warranting a response being those that would have the potential to change the agency's mind about the proper regulatory response. Such comments may include, and then we can, we've been debating the rest of the language too.
Okay, thanks, Dan. Unfortunately, we are at the time for this meeting, so we're going to have to finish this discussion at our next meeting. Sorry, Ron, I know you had your hand up. So thanks everyone for your participation and comments today. The committee staff is going to take this back, make appropriate revisions, and then we'll use that as the basis for the discussions going forward. So again, really appreciate Dan's work in getting us to this place to have this discussion, of course, and then everyone's discussion today has been very productive. So thanks, everyone.
And our next meeting will be April 15th, everyone, 1 p.m. Thank you.